I don't think that's the way to look at it. What has happened is that the Court of Appeal has struck out both appeals on which it passed a judgment today, and the appellant is very much at its liberty to pursue it any which way it feels.
Okay, so the import of this judgment, that's what you want to understand.
So that's what I'm trying to say. The judgment is that the appeal is struck out. So for various different reasons, which if you, I think, have a look at the ruling, for various different reasons the appeal was struck out by the court, which is different from dismissing it on the merits, as you have suggested, yes.
Okay.
Yes. Thank you very much. My name is nnamdikanu.
We want to understand it in a layman way, which is it was an appeal against Justice Eko's judgment, which stopped the EFCC from re-arraigning the former governor. So now, does this judgment affirm Justice Eko's judgment or otherwise? So make us understand.
Okay, well, in the real sense of it, today's judgment was actually predicated on the various notices of preliminary objection filed by the respondents. In fact, in the said preliminary objections filed by the first respondent, because we have different appeals which arose from that judgment of Eko delivered sometime in 2021. So the court today did not go into the merit of the issues between parties which were canvassed in the briefs of argument. In fact, today the court reinstated the fact that rules of court are not made for fun. If there are extant rules of court with regards to transmission and compilation of records, you must have to comply with same. You can't just overlook it and then think that the court is a marketplace where you come and then file any process you deem fit. There has to be rules that has to be followed. And that was what the appellant didn't do in this matter, which got the court frowned. And then the court had to, the court struck out their appeals, and then all the processes in the appeal were said to be incompetent. So that is actually what happened today in court. The court didn't venture into the merits of the matter for today. As it is, if you had followed the case as Supreme Court had said so, the Supreme Court made mention of the person that should be tried de novo, which is the second respondent by name Ude Jones. The Supreme Court did not mention that these other parties should be tried. The Supreme Court was specific on who should be tried, and the name of the person was mentioned. So when the prosecuting counsel sought to prosecute the other person that were not named in the judgment of the Supreme Court, then we deemed it fit to bring an application to prohibit them from doing so. So as it is today, the Supreme Court has not said that the former governor should be tried.
Sir, if you say that he wasn't mentioned to be retried, was he mentioned to benefit from the judgment in the first place?
Well, the judgment of the Supreme Court was a judgment in rem. It was not in personam, it was in rem. Anybody could, given the circumstances, to benefit from same.
Okay. What's your name, sir?
My name is Kanayo Okafor. Yes.
The court said that the records were not competent and struck out the appeal. So how do you react to this, and what is the next step you're going to take in regards to this judgment?
Well, the court did not go into the merit of the matter. The court did not go into whether Mr. Orji Uzor Kalu and SLOC Nigeria Limited can be tried in respect of the charge again. So we are not into the merit of the matter. The only reason why the court decided to strike out the appeal is simply because the person that certified the record did not include her designation. As you heard that the court mentioned that the name of the person was written on the certification as Evelyn O, but her designation was not clearly stated. So that's the major reason. There are some other legs of the objection that the court actually even ruled in favor of the appellant. So the issue of the merit of the matter is not yet resolved. We have the opportunity to come back appropriately and let the appeal be heard on its merit.
Okay, so you're saying you can come back to the Court of Appeal with still this same issue, or you go to the Supreme Court?
We can come back to the Court of Appeal easily with this same issue. The merit has not been determined because the appeal was only struck out and not dismissed, because the merit of the issue has not even been touched at all. It has not been resolved at all.
Why?
It's simply because the court decided to look at the preliminary objection and then agreed with the respondents to the effect that the certification, the certified true copies of the record of appeal was not properly certified. That the record of appeal was not properly certified. Meanwhile, it is not even the appellant that will certify, because it's the registry of the trial court that certified. So the Court of Appeal is of the opinion that if that record was not properly certified, then the record is not competent, and therefore the court cannot go ahead to pronounce on it. The court was of the opinion that it violates Section 104 of the Evidence Act. Yes, on the issue of the timing, whether the court was, the record of appeal was transmitted within 60 days, within 3 weeks. We always have the opportunity to apply for extension of time to come appropriately. So the issue of timing will not be an issue. And as it is not, the court did not say that we were the one that certified. We were not the ones that certified. It was not the appellant that certified. It was the registry of the trial court, expectedly anyway, because it's the registry of the trial court that will certify processes and all the things that were filed at the trial court that were transmitted to the Court of Appeal. So we have the opportunity, as I mentioned to the court, that we have the opportunity to come back appropriately and then ensure that the registry of the trial court actually certifies all the processes appropriately.
Thank you.
So, Oluwaleke Atolagbe. Oluwaleke Atolagbe.